Mbekezeli Benjamin. Mbekezeli, good to have you, and thank you very much for your time. Normally when we have conversations of this nature is largely because the president has delayed making an appointment of a judge, saying he's still applying his mind. And so he's taking his time in terms of applying his mind. Now, we are sitting with a situation where the president has immediately said, well, the Section 194 inquiry said, I must fire you, and therefore I must fire you. Did the president have room, leeway here to apply his mind, or, as the president puts it in his note, he had to fire the public protector because the National Assembly has already voted on the matter?
Good evening, Thabo, and to the viewers at home. Well, you're quite right. The president actually didn't have any choice. He didn't have any leeway or space for him to apply his mind. The Constitution in Section 194 is quite clear that once the National Assembly takes a resolution that the head of a Chapter 9 institution must be removed from office, then the president must remove that person. He can't question whether the National Assembly followed any type of process or whether there's any merit to the resolution by the National Assembly. He simply must carry it out. And so that's why it wasn't really surprising that the president, immediately after the National Assembly passed its resolution and communicated it to the president, that he immediately acted on it and removed Advocate Mkhwebane from the Office of the Public Protector.
So in terms of the judicial review process, then the rationality of the president is not going to come into question there in terms of him implementing this?
No, it won't really come into question because the principle of rationality in terms of the Constitution looks at two things. Number one, whether there is any logical connection between the purposes of the power that the Constitution gives you and the ultimate steps in executing that power. So really the question is, did the president look at what the National Assembly gave to him, and did he execute what the National Assembly gave him? And the answer is a simple yes. The National Assembly did an inquiry which investigated allegations against Advocate Mkhwebane. They found evidence that there was allegations or substantive allegations of misconduct and incompetence, and through that inquiry, they came to the conclusion that she must be removed from office. They then took a vote on Monday to say she must be removed from office, and that vote was communicated to the president. So in terms of the rationality test, I don't see Advocate Mkhwebane succeeding.
So we'll come to the report and the findings in a moment. Let's stick with process for a little bit. The chairperson saying, well, this was supposed to have happened in 6 months. I've heard others arguing that there was never a time frame actually that was put on this process and how long it was supposed to take. It has now taken well over a year. But he says, we are very rational, we were very patient, we were very accommodating throughout this process, ensuring that we cross the T's and dot the I's. So this, we didn't take any shortcuts. So it will not be challenged in any court of law. However, the public protector says, well, one, I was not allowed legal representation of my choice. Two, I was not even given the right to tell my side of the story on for example, some of these issues and findings of misconduct. How is that going to be assessed, I suppose, in the review process?
Well, look, we have to view all of these allegations and counter-allegations in the bigger scheme of things. The bigger scheme of things is this. Number one, this is a new process. It's a novel process that has never been undertaken before. And so it was bound to have some hiccups along the way, and which is why when the National Assembly drafted the rules, initially they said the public protector must not have any legal representation, so she must represent herself. She took that decision to the Constitutional Court, and the Constitutional Court said, no, the public protector must get legal assistance in preparing for the inquiry and participating in the inquiry. The Constitutional Court never said that your legal representative must be the most expensive lawyer in the country or that you must spend millions of rands in doing so. What the Constitutional Court said is that the National Assembly cannot prohibit you from having a lawyer present, which is what happened. And so that takes care of the first criticism, that she wasn't allowed legal representation. She was indeed allowed legal representation. The second part of the criticism was that she wasn't allowed to give her side of the story. That also is only part of the answer. It only tells us half of what happened. What really happened was, the inquiry started sitting from about March or April in 2021, and it continued until July, and then it went on and on until it reached the end in the last couple of weeks. During that entire process, the public protector was actively involved, and from March, that's when there were issues about the legal representation. But already at that time, she had submitted 2 written statements which comprehensively answered the allegations against her. There was no obligation for the committee to hear her oral testimony. It would have benefited from hearing her testimony, but it wasn't an essential requirement. And I think when the court is reviewing all of this, they will look at that, and that will be, I think, a decisive issue to say, actually, yes, you would, in the best scenario, would have given oral testimony, but giving a written statement is enough. It covers the basis, and you can't really complain and say the process didn't hear from you. It did hear from you, maybe not in the best circumstances, but it did, in fact, give you a hearing. And I think that's why, even on the second ground, I don't see her succeeding.
We should have jumped the gun a little bit still on this, but we can always go back, because I wanted to ask you first before, in what capacity would she be reviewing this process? As still a public protector, or as a private individual who's been fired from the office of the public protector? Because, of course, that would also determine who is paying for this legal process.
Well, I think as a private citizen, as a former incumbent of the office, I think she has every right to challenge the report, and in fact, she will have legal standing in her own right, because what has happened in and she's the one now who has to carry the stain of being the first public protector to be removed from office. So I think she has every ground and every right to challenge the report. On who will pay the legal costs, the public protector's office, I doubt, will be the one to pay the costs, because she's already now removed from office officially. She would have to then, I think, pay from her own pocket, or she would have to raise the funds in order to pay for the litigation to review the report.
And what does that then mean in terms of the other parties who are part of the Section 194 committee process, who are saying, well, we'll go to court and support her on this matter, to say the procedural issues are valid and she was not fairly treated in this process?
Well, in terms of Section 38 of the Constitution, anyone who has an issue with how a public power or a constitutional power is exercised has a right to challenge that decision. So even the political parties, ATM, EFF, UDM, would have a right to enter this litigation and review an act that was done by Parliament, because at the end of the day, this was Parliament acting and Parliament exercising its constitutional rights. And so the political parties would have a right to challenge the decision that was ultimately taken by the National Assembly.
Yeah. But does it not lend weight then to have review to say even some of the political parties like ATM and EFF who are part of this committee also saw that I'm not being treated fairly?
Well, it would really depend on the arguments that are ultimately made in the case. It doesn't really matter which brand of a political party is the one making it. The key question is, what would they be grounding it on? Is it, what does the law say and what do the facts say? And you'll remember that it was 318 out of 400 members of Parliament who decided that the public protector should be removed. So even there you can see it was a minority of parties that would have not voted in favor of her removal, and it will be a minority that will ultimately go to court to challenge the decision. So that is also a factor that must weigh in our heads when we look at this situation.
So I heard one legal expert saying part of the grounds that the public protector can use to challenge this report would be what the committee used to define misconduct, right? So the Democratic Alliance saying one of the issues that they found as misconduct was the fact that the public protector conducted some secret interviews or secret investigations with members of the SSA on the SACS report matter, which she did not disclose. And they found that certainly as one of the grounds for misconduct. How will the court then use that particular challenge to say, well, is that misconduct? And what defines it as misconduct?
Well, to assess whether or not it's misconduct, we have to go back to the root of how that came to be even discussed in the public arena. You'll recall that in the CX matter that was before the Constitutional Court, there were questions about the meetings that the public protector had with the State Security Agency and also with the president at the time, President Zuma, and also some of the advisors that she used in compiling the report. And those meetings were not compiled in the final report, and they were not attached into the annexures that went into the report. At the Constitutional Court, there were questions about those meetings, and she was asked to give an explanation as to why she met with certain people and why she didn't disclose that in the report. I think the judgment in the Constitutional Court said that she gave 4 different versions of that meeting or those series of meetings. And so that was how the ground of misconduct came to be. Because you'll remember that Advocate Mkhwebane is also facing perjury charges relating to the same issue. And that's because the Constitutional Court said you can't have 4 different versions of one thing. One of them has to be the truth, and you haven't been truthful in explaining your conduct at this court. And that's why now it became misconduct for the purposes of this committee, but also is a charge of perjury in terms of the proceedings at the Pretoria Magistrates Court.
So then she's arguing on the question, I mean, there are other grounds she's also arguing, but particularly on the fact that her reports would have been challenged in court, and the courts found them not to be sound, right? To say, well, that's necessarily not grounds to say I'm incompetent. Judges do that all the time. Also, their judgments are taken on appeal.
Yes, so in a way, Public Protector Mkhwebane is actually partially right in that, right? To say the majority of the cases, her reports have not really been set aside or reviewed, and in fact, the overwhelming majority have not even been taken to court. So she is correct when she says that. But the issue is not going to court or not. The issue is the conduct of the investigation. So again, if you look at the CX report, the court wasn't interested in the substance of what the report said, but in the procedure. If you as the public protector go in an investigation and you meet people and you don't disclose that in the report, that is misconduct. You're being untruthful. That was the issue there in the CX report. In the one of the Gordhan issues, the issue was the Public Protector Act is very clear that you can only investigate cases that are 2 years or less. The Gordhan issue was more than 2 years, and she failed to explain why she investigated that one. And that, again, was an issue that the court criticized her on. The same goes for the Freire report. So it wasn't necessarily that the courts were upset that she got the law wrong necessarily, or that she made minor mistakes. The big issue was her personal conduct, which is why it was subject to the court reviews, and which is why it was the basis of the charges before the inquiry in Parliament.
So the committee saying we relied, I think, on 44 witnesses, if I'm correct. We relied on some documentation. We relied on other sources of versions. But, of course, because of the back and forth around her legal representation, we did not get her version of the matters, unfortunately. How much will that weigh in this review process?
Could you repeat that, Taba? I missed it.
How much would the fact that Advocate Mkhwebane didn't place on record her version in terms of this report, how much would that weigh in this review
like
process?
I said earlier, there was a version. She did put a version of her own side or her version of events. She did put it before the committee in the form of a written statement. In fact, the written statement is in two parts, and it's available on the parliamentary website. She didn't get an opportunity to be cross-examined on that statement. She didn't get an opportunity to present that statement in full. And the court will have to assess whether that is enough for the entire process to have been unfair. And in my view, I don't think it is, but that is something that will weigh in the head of the court when it decides on whether to set this report aside or to leave it as is.
Mbekezeli Benjamin, appreciate your time as always. He is wearing his other hat today, actually. He's a UCT public law researcher.